and Michelle. Hi guys, I'm Swee Ling.
And I'm Vicky.
Hi, I'm Rui Thong.
Hi, Wen Yi.
For today's video, we will be talking about pure economic loss, and hopefully by the end of it, you will have a better insight in regards to the topic. As an extension to the duty of care, economic loss can be defined as the incurring of financial losses by an individual, to which the losses are not attributable to physical harm caused to the claimant's property. This includes the losses such as profits, trade and loss, and investment revenue. Economic loss can be defined and categorized into two types, with the first one being consequential losses. These losses are said to be claimable. This is when a claimant suffers a physical damage and from that suffers monetary loss. The types of damages include that of physical injuries to a person or one of bodily harm. The defining and leading precedent of this principle stems back to the case of Spartan Steel in the year 1973, where a power outage has caused the claimant's factory to shut down, causing the claimants to suffer from three kinds of harms: damage to the furnace and steel that were in use at the time, and the economic loss of profit of selling the steel. The courts held that they were able to claim for the losses of the damaged furnace and for the losses of profits. However, the economic loss for the profit for selling the steel was unrecoverable, as it was stated that there was no damage done to the steel. Now, pure economic loss. The presiding rule is that pure economic loss is not recoverable, meaning courts will not distribute monetary remedies to damages that cannot be directly traced back to harm a person or property. There are, however, exceptions to the rule, such as whether the loss is based on physical damage to the claimant's property, where the Negligence Act causes a claimant to acquire defective goods or property, or when the economic loss stems from a negligent misstatement. But it is to be noted that general rules of negligence still apply here, so there should still be a duty of care that is in line with the Caparo's test and a breach of duty that causes the loss. Another case regarding economic loss would be that of cattle and stock from waterworks, in which the main issue was whether cattle had a right to recover losses from waterworks in circumstances where there is a wrongdoing done by a third party. The courts did held that the damage sustained by cattle by reason of this contract with the landowner becoming less profitable did not give him a right of action against waterworks. Their negligence did injure the property of the landowner but did not injure any property of cattle. Cattle therefore had no rights of recovery for his contract becoming less profitable than expected. There is, however, sufficient grounds for cattle to claim loss. The fact that the landowner could have indicated for nuisance to the road would not have rendered the proceeding so illegal as to prevent cattle from recovering damages to a wrong.
Moving forward, I'll then address some of the pure economic cases caused by the defective property in England and Wales in relation to the questions. Initially, in the wake of Donahue and Stevenson, the builders retained an immunity in English tort law in respect of defective construction work. If they were working under contract, the obligation will confine to contractual obligation to other contracting party. While if they were speculative builders building on their own land and then selling the property on, they benefit from the vendor's immunity in respect of the condition of the property. However, the abolition of builders' immunity could be found in 1970s cases. The court recognized claims for losses arising out of the defective construction of a building which does not comply to the general principle of pure economic loss in current tort law. First of all, the pure economic principle regarding to defective property was first developed in the case of Ants and Merton London Borough Council, which involved the negligence of builders in the result of monetary loss. The claimant were tenant in a block of flats and suffered from structural defects due to inadequate foundation, which was approved by the local council. The claimant sued the local council for the duty of care owed with respect of the damage which he had suffered. On the basis of the two-part test, and there were no policy grounds to avoid imposing a duty, the court held that the defendant liable to ensure the foundation were of the correct depth. As in Lord Wilberforce will, the plaintiff had suffered material physical damage. Much of the relation behind Ants was based on the assumption that it was the purpose and the duty of a local authority to protect the physical and economic welfare of its citizens. Although these cases were principally concerned with local authorities' duty, they also considered the duty that ought to be imposed on builders. Therefore, hence two-part test is a high watermark in respect of recovery of pure economic loss.
Hi, I'm the builder.
Hi, I'm Merchant London Borough Council.
Oh, here's my plan.
This is your plan. Okay, let me look at the work first. It's according to the plan. I think I will approve this plan.
Hello, I am Anne. This is my new, beautiful, crackless house. Look how beautiful the wall is. It's so white, it's so perfect. Oh my gosh, I am loving this. Oh no. I'm gonna sue them now.
The principle of N was then extended in the case of Junior Books and Vetici. In this case, the claimant's architect nominated defendant to lay claimant's floor. As a result, the defendant subcontracted to the main builder to complete the work. However, the defendant had laid the floor wrongly and had to be relayed. The claimant was not allowed to sue the builders who had hired the floor layer at the claimant's request, and they had no contractual relationship with the floor layer. However, the claimant won compensation including the cost of relaying the floor as well as the profit they were supposed to generate due to the delay of completion. There are three key issues which has contributed to the result of this claim. First, the claimant has nominated the defendant, and so they relied on the defendant's skills and judgment. Second, the defendant were aware of this reliance at all material time. Third, the damage caused was a direct and foreseeable consequence of the defendant's negligence. As asserted by Lord Facer, there are sufficient proximity between both parties. Therefore, Junior Books fulfill the three principles of Halley-Bryan. However, there are dissenting judgment. Lord Brandon criticized the other judges for creating obligation which is only appropriate as between contracting parties, and he was very concerned on the boundaries between tort and contract. He argued that contract focused on issues of quality and tort focused on issues on damage. There could be no objective test as to reasonableness of quality, and so tort was an inappropriate medium for determining defects in quality. Soon after the decision in Ants and Junior Books, the court started to limit the principle, as the judges considered that the relaxation of the principle concerning recovery of economic loss had now gone too far. A long line of cases followed which tried to limit the scope of the above cases. The builder's duty at common law was largely dismantled by the House of Law decision in the case of D&F Estate and Church Commissioner and the case of Murphy and Brentwood District Council for England.
Well, yes, I totally agree with what my groupmate Rui Thong has mentioned just now. There are plenty of issues which have arisen as the current tort law in the UK does not provide any remedies for pure economic loss which have actually caused by defective property. Besides, it does not provide valid justification for a legitimate claimant which is adverse to the decisions in the Ants case as well as the Justice Books case, which were both mentioned by my friend just now. So, in order to identify the issues brought by the unquantifiable claims, the cases have to be identified accordingly. So first and foremost, in the case of D&F Estates and Church Commissioners for England, which was decided in the favour of the defendant in the year of 1989, the builders who were hired by the contractors were negligent when plastering a property, and 15 years later they found out about it. The claimant sued the builders for the defective property, and the court held that no duty was owed by the builders because the builders had satisfied their duty by hiring competent tradesmen, and there was no physical damage caused but purely economic loss only. In the case of Murphy and Brentwood District Council,
Hello, I am here for the house.
I'll show you the house.
Okay.
It's the most beautiful house I have ever seen. Now it's worth 5 ringgit, but I can give you 4 ringgit.
Okay, I will take this very flawless house for 4 ringgit.
Thank you.
Welcome. I am having the time of my life sleeping in this flawless house. I am having the time of my life sitting at this flawless house.
Hi dear.
Hello.
Hi.
We are having the time of my life sitting in this father's house.
I like this flawless house. Let's get some friends over.
Hi guys! I know, right? It's flawless. We are having the time of our life in this flawless house.
Perfect house, you must come over again. Oh my god.
Bye guys.
Bye.
I am now looking at the ceiling of the flawless house. It's not flawless. It's got a crack.
One.
My house isn't flawless. It's terrible. My friends are gonna laugh at me. I'm gonna go find the agent now.
Yes, how may I help you?
My house is not flawless. What can I do?
My job is just to approve the plan. I think you should find the builder since he built the house for you according to your plan.
Okay, I go find the agent. Hello, agent. My house is not flawless. What can I do?
It's not like not responsible. You need to pay by yourself or you sell it.
Okay, I'm going to sell the house. How much can I sell the house for?
It's only 2 ringgit.
2 ringgit. Okay, I will sell the house for 2 ringgit.
Yeah, sign here.
I'm going to sue them. That was so unfair.
So the Murphy case has contributed to the most arguments due to the similar facts in comparison with the Ants case. So the claimant acquired a new property and later then found out it was defective. He could not afford the repairing expenses, so he had to sell it at a much more lower price, which has resulted in a pure economic loss. So he sued the local council as the local council had previously approved this defective footage of the property, and the court held that
I'm not rich and I will be delivering the judgment for this case. We have distinguished this case from junior books, as in this case, acquiring a defective property shows an absence of special relationship of proximity in imposing on the tortfeasor a duty of care to safeguard the plaintiff from economic loss.
Well, however, the issues arise when comparing the cases of Ants and Murphy. Both of these cases have very similar facts, but why are the judgments different? So in the Ants case, it is accepted that builder is liable if he negligently constructs the premises with the end result of collapsing, which will cause injury to the owner. Why then he should not be liable if the owner discovers the defect? If the owner discovers the defect and in time and spends money himself to avoid the threatened calamity in the case of Murphy. Well, the loss-ships ratio is as follows. So if the owner discovers the defect, and then he is no longer in danger because it can be avoided by spending money to repair it. So then the only loss would be the economic cost of doing so. Hence, if one discovers the defect, meaning that he is responsible for his own danger and also injuries. However, this reasoning is argued to be incorrect. So it is well recognized in our modern product liability law that the issuing of a warning from a manufacturer as to the dangers of a product will not prevent him being liable for injury unless the warning enables the customer or consumer to be safe. So Murphy namely that the same principles must apply to all the premises. Well, even if it's true that on discovering the defect of the property can avoid all dangers by discarding it, this is not usually true of the owner of the defective premises. Mr. Murphy's house was half into the value when he discovered the defect of his property. So he was insured and able to move. Otherwise, he would have had to remain in the house, which will cause him injuries due to the defective footings. So even if it is considered that this was a claim for a pure economic loss, we need to ask why. why ends should not be extended so as to allow the purchaser of premises a claim against the negligent builder for the defects which diminish its value.
As aforementioned, the result of the reasoning in Murphy was that the subsequent purchaser not only could not sue the local authority, but because the purchaser was seen as having suffered only economic loss of repairing defects in the building that have not yet caused personal injury or damage to other property. The purchaser could not sue the negligent builder either. This left a subsequent purchaser without any remedy at all. The House of Law were aware of the consequences of their decision, but reasoned that the law will be improved by discarding the Ant's proposition, not because they were unjust, but because they constitute an incorrect statement of the true common law and had in consequence thrown the law into confusion. The liability it created was endless. The law should be constituted of rules which are susceptible of proper free application, the so-called bring lines requirement.
Now we will be looking at the principle of economic loss in other common law jurisdictions. The first country we will be looking at is Canada. The Supreme Court in Winnipeg Condominium and Bird Construction Co. Limited classified building defect as pure economic loss, which was recoverable using the N-style two-stage test for duty based on forcibility of harm and policy. Supreme Court of Canada Justice Lawford stated that contractors as well as subcontractors, architects and engineers who take part in the design and construction of a building will owe a duty to the subsequent purchaser of that building if its reasonable care in constructing the building would create defects that pose a substantial danger to the health and safety of the occupants. What happened in the Bird case was, the Bird construction built some condominium which had a flaw in the masonry work. This flaw was not discovered by the initial owner of the building. Winnipeg subsequently bought the condominium and the flaw started to fall off from the 9th floor. Winnipeg had to make significant repair and sued Bird to recover the amount of money. The court refused to follow the D&F Estate Limited and Church Commissioner for England and Wales, disagreeing with the concern expressed in the case that to allow an action in tort would encroach on contractual rights and obligations. Murphy case was seen by the Canadian court as a decision strongly influenced by the D&F Estate, so it follows the Murphy and the principle underlying it also were rejected. The second country we are looking at is New Zealand. The first recognition of a duty for defective premises came in the Bowen and Paramount case in 1977. A builder was held liable to a subsequent purchaser for damage to a house resulting from inadequate foundation, where the house posed a danger to the person or property. This decision was not based on the fictional moving of the dividing line between the defect and damage proposed in ends, but rather by seeing the foundation of the house as separate to the house itself, such that damage can be said to have been caused to the other house the other damage. Then, in 1994, in Invercargill and Hamlin, the New Zealand Court of Appeal was presented with an opportunity to state its position on liability for defective premises after the Murphy case. Invercargill was a classic defective foundation case like Bryan and Maloney. The Court of Appeal confirmed that despite English development, Bowen remained a good law in New Zealand. Beyond that, there was a detailed discussion on the liability of a builder for defective premises. It was assumed that Bowen was unaccessible on this point. Discussion on Invercargill focused on the potential liability of the local council for negligent inspection of the foundation, an issue raised in Murphy. The House of Law in Murphy made quite clear that despite policy reasoning which imposed a duty on the local authority in ends, modern political and economic theory presenting individual responsibility to community responsibility no longer supported allowing a house owner to pass on loss to the insurance. The Court of Appeal in New Zealand was unimpressed by the reasoning in Murphy on this point and regarded it is unapplicable given that the different social attitude to housing and to the role of local council in that country. The local council was held to owe a duty to the house owner. Murphy had not been followed in New Zealand and the Privy Council accepted that this was justified. The third country we'll be looking at is Singapore. In the pure economic loss case of RSP Architects and Oceanfront Private Limited, the Court of Appeal, while not specifically exposing Lord Wilberforce's broad proposition, used a two-stage process to determine duty. Their honours also applied the Junior Brooks case a rarely followed decision of the House of Lords under which the Ends two-stage test has been applied to allow recovery in the tort for pure economic loss arising from a defective premises in near contractual circumstances. However, the court in the ocean front ultimately based its decision on the notion of proximity and indicated that there were no single set of rules for determining whether a duty of care should be held to exist in a particular circumstances. In the subsequent case of RSP Architect and Management Corporation Star Rata Title Plan number 1075 and another, which are also known as Eastern Lagoon, the Court of Appeal notionally rejected the Ends test while adopting a subsequently similar two-stage process. As we can see from the case of Sunrise Crane and Chipter Marine Private Limited and TV Media Private Limited and Andrea D. Cruz, although the Singapore courts adopted the two-stage test to determine cases concerning pure economic losses when it concerned cases involving physical damage, the Singapore court until recently continued to adopt the three-part test established in the English case, Caparo, namely forcibility, proximity, fairness, justice, and reasonableness. In the recent Court of Appeal decision of Spandex Engineering and Defence Science and Technology Agency, the dispute between a builder and certifier in which the former had sued the latter for negligent certification. This case is important as it laid down on important common law principle regulating the duty of care in the tort of negligence. The court held that a single two-stage test of kind proposed by Pang Justice in Sunny Matter, comprising first proximity and then policy consideration, should be used to determine the existence of a duty of care in all situations, regardless whether the damage complained was physical or purely economic, although a more restricted application might be preferable in cases of pure economic loss. The test developed in the context of pure economic loss cases initially focused in the terms of proximity on the twin elements of assumption of responsibility and reliance. In Spandex, the Court of Appeal held that the test was to be applied incrementally with reference to the facts of decided cases. Absent of such cases would not be an absolute bar to finding of duty. It is also held that while the threshold of factual possibility would remain, it would not be necessary to include it as part of the legal test for duty.
As we have seen from the works of my teammate, that the usual position of the UK is that pure economic loss arising from defective property is not claimable. However, we have also seen that in other jurisdictions, these losses from the defective property is claimable, and therefore it will be crucial for us to address the issue pertaining to why some countries allow it and some countries doesn't. As you have seen, that courts have to deal with many negligence claims against architects, builders, engineers and developers. And when we look at the case of Ants and Merton Borough Council, it is true that despite the courts allowing the claim for a defective property in terms of pure economic loss, it is, however, held that it is on a basis of an unsatisfactory legal principle. And Lord Wilberforce laid down the basis of the claim, which is a cause of action arose when the building became imminent danger to the health and safety of the occupier, who could then recover the cost of averting that danger. In this case, however, we can argue that the claim was not to allow pure economic loss for a defective building, but rather it expands on the principle laid down in Donoghue and Stevenson, which allows for a claim for someone who has not completed their duty properly. In exploring the current position of the UK in terms of pure economic loss in a defective property, we would turn our heads to Murphy and Brentwood District Council, which in effect overruled Ants, where it is evident the judgment given had more weightage on the fact that the loss suffered by the plaintiff was pure economic loss, despite having similar facts to Ants. In the case of Murphy, the claim was rejected due to an existence due to a lack of existence of a special relationship between the parties. Hence, economic loss arising from an acquisition of a defective building was not recoverable in law. As to why Murphy's case was decided as it is, academicians such as Christy Jose has speculated that the judicial adversity to a claim for pure economic loss arising from defective properties was due to a more conservative political climate. Thus, it would seem to us that in the UK, especially in England and Wales, the courts are reluctant to impose a duty, especially in the absence of a special relationship, to a third party, as there are already many existing avenues for a claim as such. One of them would be through contract law, where Section 1 of the Contracts Right to Third Party Act 1999 has already conferred the right to third party, as most acquisition of properties would have required for a formal contract. Thus, the Rights of Third Party Act 1999 has already served as an avenue for a claim in the capacity of a third party without having to have a special relationship through a contract. Therefore, it would be logical to conclude that the English courts do not wish to open a floodgate of litigation, as laid down in the case of Alta Maris Corps and Tache, 1931, in an indeterminate for an indeterminate time to an indeterminate class of people in which an action might arise, if the courts allow claims for pure economic loss, especially from a defective property claim. Thus, it shows a rigidity of English common law where judges are not willing to cause uncertainty in terms of judicial precedents. Of other common law jurisdictions, such as Canada, claims has been allowed for pure economic loss arising from defective property. In Canadian courts, the courts have justified their claim or their decision by saying that they do not think that allowing for claims arising from defective property would encroach into the territory of contract law, and hence they have refused to follow the case of Murphy. Therefore, we would now move on to our conclusion, in which we would see whether it is fair or just for a court to reject claims of pure economic loss arising from defective properties. Thank you.
Although pure economic loss is said to be non-equitable, some cases have shown this court holding to be slightly unfair and in many cases questionable. It would be best for judges to consider every fact and circumstances within cases and cross-examine them with utmost care, as to minimize any sort of unjust court holdings in the coming future as much as possible.